I call the honourable member Dennis O'Rourke.
Mr Speaker, New Zealand First supports nearly all of the amendments to the standing orders which are proposed. We've participated in a collaborative process which has resulted in a number of very worthwhile changes, and I only wish to refer to three of them. The first one was proposed by New Zealand First and was adopted by the committee concerning Standing Order 34, recognition of parties. We were very concerned at the events which followed the registration of the United Future Party recently. We were especially concerned at the way Standing Order 34 was applied to the situation which United Future was in. We considered that the re-registration of that party for parliamentary purposes following its new recognition under Part 4 of the Electoral Act 1993 to be illegal under Standing Order 34. It was New Zealand First's understanding that the status of a party for parliamentary purposes is determined at the date of the last election or, where relevant, as at the date of a subsequent by-election and at no other time. This is clearly expressed in Standing Order 34.1, which requires firstly that the party be then registered under Part 4 of the Electoral Act 1993, and secondly that it have a member elected in that party's interest as at the last general election or subsequent by-election. It's also clear that following deregistration of a party under Part 4 of the Electoral Act 1993 during a parliamentary term, Standing Order 34.4 applies, and that any Member of Parliament who had been one of that party's recognised Members of Parliament as at the last general election or subsequent by-election then becomes an independent member for parliamentary purposes under Standing Order 34.4. With regard to the new recognition of an independent member as the member of a recognised party, Standing Order 34.2 has two components. One deals with an existing recognised party and the other with a new party, which becomes recognised under Part 4 of the Electoral Act 1993 and has at least 6 members. It is the situation in paragraph A which caused concern and which was the part applicable to the situation which United Future was in, with only one member at the relevant time. It's particularly the use and meaning of the word existing in paragraph A which was the root of the problem. It was New Zealand First's understanding, based upon the usual rules of interpretation and based on the scheme and intent of the statute as a whole, that the word existing can only mean existing as at the date of the last general election or subsequent by-election, having regard to the content of Standing Order 34.1. Therefore, in the case of United Future, once it had been deregistered and its one member had become an independent member, that member could not subsequently be recognised as a United Future member again, even if the party was re-registered, because under paragraph A, the party having been re-registered with new or additional members could not be the same party as the one which had been existing as at the last general election or a subsequent by-election. Nor could United Future have been recognised under subparagraph B as a new party because it did not have 6 members. New Zealand First believed that whether our interpretation was correct or not, it would be very desirable for Standing Order 34 to be amended and clarified in these respects. New Zealand First therefore proposed that Standing Order 34 be amended accordingly, and that change will, I'm pleased to say, will now be made, but it is subject to the prior requirement that the Speaker will have the authority to grant parties temporary recognition for a reasonable period. But thereafter, if a party ceases to be recognised, it can then subsequently only be re-recognised if it meets the criteria for a new party. And in particular, it would then need to have at least 6 MPs. Another change, but one with which New Zealand First did not agree, concerns the way bills are handled which are thought to be inconsistent with the New Zealand Bill of Rights Act, how that's to be dealt with. We believe that the recommendation for reference just to a standing committee is insufficient. We all know that the result of that can be little or no real consideration at all, and that's really not good enough for something as important as the possibility of inconsistency of proposed legislation with the New Zealand Bill of Rights Act, an incredibly important matter. We felt that reference to the Committee of the Whole House and a full debate with the benefit of comprehensive reports would at least be necessary. So this is something of a work in progress for us. We believe it's something that will need to be followed up at a subsequent time. The only other change I wish to comment on are the new rules and procedures for Members of Parliament's attendance. The standing orders needed to be updated on that, and it needed to be made clear that there would be a sanction for MPs who do not attend regularly. There have been very few who have fallen into this category because party discipline has usually taken care of the issue. But with some MPs becoming independent or being one-person parties, it's wise that these new rules be incorporated. So, Mr. Speaker, with those changes, the ones that I have mentioned, and with our approval also of the various other changes, and there are many, New Zealand First will be happy to vote for both of the motions.
I call the honourable member, Sue Moroni.
Thank you, Mr. Speaker. Thank you. Mr. Speaker,